conclusions, whatever you want to say, that were inputted by that user. 96.39% of those would have been approvals or passes, or like we talked about earlier. I hated the word accepted for the reasons that we talked about. So a pass.
Okay. And then continuing on.
As you go to the right, under the column that simply stated less than 6 seconds, there were 36,086 instances where that user did that. In those instances, the pass rate of those was 99.65%.
Objection, Your Honor. Again, what I'm hearing here is a summary of a document, or I should say of CD-ROM, leading to what I'm hearing is our statistical conclusions. Again, I think we've made our record, but I just want to read the
True. The objection should be foundation, I believe, as to if he's going to use a number, he can do the math and show his work. So that's the objection on foundation. So how did he get the 99.65% for the last thing he testified to? That's the objection. If you could have him show his math.
Yes, sir. Mr. Speaker, with respect to the 99.65%, with this table, we're just talking average, correct? Average and averages and percentages, correct?
Not even average, just percentage on this table. Correct, yes.
Where does the 99.65% derive from?
That's the number of passes or accepted signatures, good signatures, compared to the overall number of determinations made. So in simple terms, if they made 2 determinations and one of them was a pass, 50%. Made 2 determinations and 2 determinations were passes, 100%. They made 10 and one was a pass, 10%. It's super easy.
Next question.
Continuing on with, in simple terms, the column which is less than 4 seconds, can you just continue to the right with user number 20 as to what this data shows?
Yes. So for that user, 24,904 were done at that speed or faster. In other words, the less than 4 seconds. So obviously the ones that are included in that column were previously included in the one where we had a larger time that we're analyzing. This is a smaller subset of the same data. And of those, the approval rate, 99.87. So we get 13 out of 1,000 are not included, 9,987, or I'm sorry, out of 10,000, 9,987 out of 10,000 were passed.
Continuing on to the column less than 3 seconds.
So that total number of instances where comparisons were done, where the keystrokes were entered in that amount of time is 13,749, and 99.88%. Simple conversion, 12 out of 10,000 were not passed, the rest were.
If we selected number, let's take user number 31. Could you go through the same recitation that you just did with respect to that user as to what this table reflects?
Sure. Same principles apply. They did 46,854 determinations. The overall, call it approval percentage, passing percentage, 97.23%. At a time of less than 6 seconds. Of those 46,000 instances, 37,588 of them were done at that rate of less than 6 seconds. And for that, the approval percentage for that subset, 99.37%. Moving to the right, less than 4 seconds, 29,751 instances. Approval percentage 99.72, so it ticks up. And then even faster rate of less than 3 seconds, 21,471. Approval percentage, 99.84.
Let's, if you would move over to the third page with user 72. Or strike that. Let's go to user 79.
Your Honor. Objection, the witness is testifying to these numbers as if they are admitted for their truth. They are not admitted.
No, these are his opinions based upon what he's reviewed.
Is it-
So overruled for that. Go ahead.
So user 79, Mr. Spakeen?
Same takeaway for 79, 54,298 in total, the total body of work. 98.9% approvals. You go to the next column of what we're calling less than 6 seconds. 45,217 approved at 99.91. So in simple terms, 9 out of 10,000 would not be approved. At the next fastest rate of less than 4 seconds, 37,524, 99.97. And the last column of 3 seconds or less, 27,196 instances with 100% approval percentage.
Looking at the approval ratings going from less than 6 seconds to less than 3 seconds, what do you see about the approval rating?
Well, they're all very high for this user, but the faster they go, the more they get approved, the higher the rate for this user.
Does that seem unusual to you?
It definitely seems counterintuitive. It's also against my experience. The faster you go, it would be a rejection. It's easier to tell something doesn't match when you're doing a comparison, not that it does match.
Turning to the last page, Mr. Spakeen, and the total verification. Under the total, can you read the totals for the various columns, less than 6, less than 5, less than 4, less than 3?
Well, we only have 3 columns, so we have less than 6, less than 4, and less than 3. And the first one, less than 6, 779,330, 779,330. The next fastest time, 512,597. And the fastest time on the table, less than 3 seconds, 321,495 instances or times that occurred.
And my recollection is there is a lower figure for comparisons at less than 3 seconds, around 276,000.
Well, my opinion for the comparisons that were actually done in less than 3 seconds is less than this 321,495 number, because user 26 and user 9 had some activity that appears to be inputted through a computer by some algorithm or some script. I didn't think it was fair to count them, or it would be misleading if I did count them, if indeed they were put in through a computer or some algorithm, as saying that the keystrokes were done in that time. If I'm wrong, the number would go up, from my opinion, to what's on the chart. I just believe that's what was inputted.
So your opinion, would that subtract the number of ballots processed by user 9 and 26 from the total of 321,495?
Yes, so for the rate, the count or the instances or the rates, I think it would be correct to subtract that number to arrive at a smaller number. As I said, 321 minus 44, or it might be 45 when you add them up, 45,670 from that number.
Did you assess any rate of less than 2 seconds?
I did. I ran the search further out than shows on this table, yes.
And what did the data reflect?
There were about 70,000 instances, accepting or removing the 26 and 9 that I just talked about that were lightning quick. Removing that, roughly 70,000.
So roughly 70,000 signatures processed in less than 2 seconds?
No, I would use the word compared.
Compared, excuse me.
Process would be a bigger number because you'd include 26 and 9. Compared would be the lower number, yes.
And do you recall any figures with respect to the approval rating?
So I did look at the users that had over 1,000 instances of that less than 2 seconds comparison, and 7 of them had 100%. I remember that.
What is your expert opinion as to the physical ability to compare a signature for consistency in less than 3 seconds?
I don't believe it can be done. I look at this all day, every day. This is what I do, and I've done for 30 years, handwriting and signatures. I'm not going to sit here and tell the court no one in the world could be better than me, but I really do believe I'm at the top of the pyramid of who could do this and how to do it. If I can't do it, I don't see how anyone could do it on a mass scale, day after day after day, hour after hour, at these rates. It can't be so.
And how are you using the term compare?
Well, compare to me, this morning I just Googled what does compare mean, and it says to look at carefully to see similarities and differences between two items. Obviously, in this case, we're talking signatures. That's what it means to me anyway, but to give you the definition that I read this morning, that's what it said.
And what is your understanding of the Arizona statute that governs signature verification 16550?
Well, it says that they should be compared, and then it infers after that for consistencies or inconsistencies, based on this is the path for an inconsistency. It uses the word compare. The standards that I use in my field and the standards that are written use comparison and compare. The training manual use it. It was at least had input from someone like me. I don't want to drag her down to that level if she feels differently, but someone with similar background to me. It's a common word that we use in the English language, and it's no different in my industry what the word compare means.
Your Honor, at this time, we have no further questions.
Very well. Who will be conducting the cross?
I will, Your Honor.
Morgan, go ahead and proceed as soon as you are ready, sir.
Your Honor, may I use the podium?
You use the podium, sir.
I want to make sure I say your name right because I'm not particularly great with names. Spakeen?
That's actually right. I was going to say use Eric if you feel comfortable, but Spakeen is correct. Yes.
Thank you, Mr. Spakeen. You'll agree with me in your profession, detail is a thing. It's important, right?
Absolutely.
Devil's in the details, as they say, right?
perhaps an overused phrase in our language, but I don't disagree.
Okay. And you'll agree with me then that in connection with the signatures that we were just hearing you testify about in Exhibit 47, which is a demonstrative, you didn't personally do any of these signature comparisons yourself, correct?
That's right. I wasn't the level 1 reviewer or level 2 or whatever.
You haven't seen any of those signatures, correct?
Correct. I haven't seen a one.
And you'll agree with me then, in the realm of possibility, it's entirely possible that many of those signatures completely matched.
Well, I suspect some would have, yes.
Okay. Now, again, I want to talk about details. Earlier in your testimony, my colleague brought up a case in Hong Kong. Do you remember that case?
I remember very well.
It's Nina Kung versus Wang Dinxin. Does that sound about right?
That sounds correct. More or less, yeah.
More or less. All right. You had testified that there was an opinion from a higher appellate court that essentially said the intermediate or the lower appellate court got it wrong with respect to you. Is that right?
I said the initial trial court. I didn't say the lower appellate court.
Okay.
There was an intermediate appellate decision, but I didn't say anything about that.
And you, if I understood your testimony, and I'm summarizing, you feel like that appellate decision vindicated you essentially.
No, I'm saying it backs up the fact that the judge copied what the other side wrote.
Okay. Well, I would like to show the witness, Your Honor. I'd like to approach the clerk and have this marked as next exhibit. It's the it's the court case that he mentioned in his direct, Your Honor. May I approach him?
You can mark it and you can approach him with it right now for
Thank you.
impeachments. We'll talk about admissibility and later. Got another copy.
May I?
Please.
I believe exhibit 48. Do you have that in front of you?
It doesn't say 48, but oh yeah, it does. I have it, yeah.
Okay. I want you to turn with me. There's some numbers there at the bottom, okay? I want you to turn with me to page 91. Would you let me know when you're there?
I'm there.
All right. I'm going to read aloud paragraph 452, okay?
Okay.
This is the decision from this appellate court in Hong Kong. I do not find these arguments excusing the judge convincing. Not only was the evidence on Eek dating wholly unsatisfactory, Mr. Spakeen himself was wholly discredited as an expert witness for, among other things, claiming professional credentials that he lacked, claiming acceptance of his methods by the scientific community when that was false, and having been trapped into demonstrating that his opinions were quite unreliable. It would therefore have been wholly perverse for Yam J to do other than reject that evidence. However, even then, Yam J did so by copying verbatim almost the whole of the appellant's submissions inviting such rejection. Did I read that correctly?
Absolutely.
And you'll agree with me then that what the appellate court is saying is that the judge got it right.
I don't believe that's what's in the entire opinion.
Well, let's talk about what I read. I only want to talk about
For that one paragraph, does it
Yes.
say that? Of course.
If you like, you can take a moment to point to me anywhere in the opinion where the judge vindicates what you did and says you did a good job.
I don't have one that says exactly that, but we have wholesale copying and an unfair trial is paragraph 445
Sure.
and paragraph 90.
Yeah, but the paragraph we read said to declare anything other than you falsified your credentials would be perverse. Those are his words, not mine, correct?
That was the words of the person who wrote that. Yes.
Okay.
I'm saying there are other paragraphs that don't say the same thing. That's what I'm telling you.
Can you point me to one that contradicts that paragraph?
It just did.
Let's
445 on page
Hold on.
90.
slow down. Court reporter's trying to keep up.
Now, you recall testifying earlier about your involvement in a case called EEOC versus Ethan Allen. You recall that?
I do.
And that's in the federal district court in the Northern District of Ohio, correct?
It was, yeah, it's 20 some years old.
Honor, may I ask what it's on?
You can approach the exhibits, but ask about approaching the witness, please.
Exhibit 40.
I do?
Okay, let's talk about Exhibit 40. Is this the case that you were giving testimony as an expert in?
I never gave testimony as an expert. I gave a deposition, but never.
That's right, because you were excluded as an expert in that case, correct?
Correct, that's what I said.
Okay. Now, let's talk about this case for a minute. You gave a statistical opinion in that case, didn't you?
I did?
And the court discredited you based on your lack of qualifications to give a statistical analysis, correct?
Don't believe so, but you could point me to the paragraph
Sure.
that says that.
I'm happy to do it. Let's take a look at page 6. I'll read it aloud. Many of the criticisms leveled at Spokane by the Wayne court could also serve as a basis for this court's conclusion that, based on the standards imposed by Daubert, Spokane's testimony is inadmissible in this case. Ultimately, however, the court finds two particular grounds especially compelling and independently sufficient to justify its conclusion. And the first being, Spokane's statistical analysis is deeply suspect. Now, I ask you again, you were excluded from testifying in that case because your statistical analysis was suspect, correct?
The analysis at one standard deviation, yes. But you asked me if because of my knowledge. I
As a
misunderstood.
yes, no, we're fine. Your Honor, I move exhibits 40 and 48 into evidence.
Okay. Any objection?
There you are.
Okay, they're admitted.
Now, let's walk through, I want to revisit the Wang case. And let's walk through the information that the trial court said and that the appellate court found. It would be perverse to have concluded that you could be an expert otherwise. They conclude in the Wang case, he did not study, well, actually, handing you what's been marked as Exhibit 40. Exhibit 43 is a copy of a decision from the Court of First Instance in the Wang case. Do you see that?
I do.
Can you please turn to page 211? Just let me know when you're there.
I'm there.
Now, at paragraph 29.5, the trial court in Hong Kong said he did not study statistics either in his BA degree, and that is why he was not awarded a BSc degree. He is plainly deficient in his knowledge of statistics and chromatography disciplines, one would have thought essential for an analytical chemist, essentially one who offers himself to the court as an expert, even more so for one who claims to be that one of the world's leading experts in one particular branch of analytical chemistry, i.e. ink analysis. Did I read that correctly?
You did?
And do you disagree with that statement?
Absolutely.
Let's go to 29.8. Same page. He attempted to magnify his experience by claiming to have examined over 100,000 documents. When the sheer mathematical impossibility of this was pointed out to him, as it would have taken him 274 years to do it, he claimed that simply flicking over pages looking for something else amounted to an examination. Remember giving that testimony?
Absolutely not what I said.
Didn't tell the court that, in your opinion, that you flipping over the pages amounts to an examination.
That's absolutely correct. I did not say that.
Okay. Goes on to read, obviously has examined many documents in his short experience, but there's no way that this court can evaluate the extent or depth of that experience. This lack of experience may account for the reason why neither he himself nor his laboratory are included in ASTM's directory of scientific technical consultants and expert witnesses. Did I read that correctly?
You did?
Now, other courts have taken issue with what they consider to be misrepresentations about your experience, correct?
I can recall one court that sent me a letter,
Uh-huh.
clarified with the judge by replying. But that's the only time I can think of that.
Okay. Your Honor, I move into evidence exhibits 43.
Any objection on 43?
There you are.
43 will be admitted. You may.
Thank you. That's been marked as exhibit 41.
I do?
Is this the letter you were just referring to?
Yes.
And this is a letter that was sent to you from the 13th Judicial Circuit from a judge, Philip E. Rogers Jr., Circuit Court Judge. You see that?
I do?
And this was a case called People versus Douglas William Adrian, correct?
Yes.
And you were appointed as an expert by the court in that case, correct?
Yes, the court appointed me as the expert. That's
Court
exactly
appointed
correct.
you. Right, and this is a letter from the court that appointed you.
That's exactly right.
Okay, and the first sentence says, the court authorized your retention to provide expert witness services to this defendant. Next paragraph, however, I was extremely disappointed in your presentation. While I initially found you barely qualified to offer an expert opinion in this case, upon the completion of your examination, I came to the conclusion that I had made an error. The last paragraph on that page says, you also need to address the issues associated with your resume. You certainly did the defendant no good whatsoever when you were confronted with an affidavit to which a lawyer's weekly article had been attached. This was a clear indication to the court and the jury that you countenanced an overblown statement of your credentials as they related to your work with the IRS and the Secret Service. You recall reading that when you saw it or when you received it?
Of course.
I move Exhibit 41 into evidence, Your Honor.
Any objection?
There you are.
41's admitted.
Now, you testified earlier, I think I heard correctly, that you were you gave testimony before one or both chambers of the legislature in Arizona.
Yes, I said I wasn't sure. I thought it was.
Yeah,
at the
of
same
course.
time, but
Yeah,
I said
one
that.
or both.
Yes, I said that.
That was when?
I don't remember the date, a couple months ago.
Okay. And that was in connection with work that you performed for an audit in 2020, right?
I don't know if I would say audit. It was work that I had performed on the 2020 ballots.
Was that related to what might be commonly referred to the Cyber Ninjas audit? Does that sound familiar?
Well, it was completely different from what they were doing. It was happening at the same period of time. So in that sense related, I mean, I wasn't working for them and they weren't working for me.
And your ultimate conclusion in connection with your findings was that you couldn't really make a conclusion. You needed more information, correct?
I wouldn't say that, no.
Okay.
You may.
Handed you what's been marked as Exhibit 38. You recognize this?
I do?
Did you create this?
Did?
And this is your executive summary related to the work we're discussing now, correct?
Right. I testified to more districts in front of Arizona, but specifically related to what happened in Arizona. This is the summary.
Okay. Your Honor, I move Exhibit 38 in evidence.
Objection?
There, Your Honor. Okay.
38's admitted.
Thank you, Your Honor. Okay, can we please turn to the second to last page of this exhibit?
It's two-sided. Do you mean, what is the first word at the top?
The first word at the top is going to be when the contents of the box were examined.
I'm there.
You there? All right, let's go to the bottom. You see the section that says summary and discussion of further forensic review.
Yes?
Based on the forensic findings, it is my opinion that further work and review of the ballots, or the images at a minimum, should be conducted to determine what significance these findings have on the whole of the ballots cast, as well as possible statistical significance of the votes contained for a particular ballot item. Did I read that correctly?
Absolutely.
This is your conclusion.
Well, that's one of many, but you read that
The
correctly.
conclusion then was that more work needs to be done.
Well, it's my conclusion I would do more work.
Okay, now, the testimony, and I'm calling it testimony loosely, I understand. I don't know whether you're under oath, I wasn't there and you didn't say you were. But the testimony you gave recently in front of the legislature, okay, you with me so far?
Yeah, I know what you're
All
talking
right,
about.
good. You were invited by whom to give that testimony? Liz Harris?
No.
No?
Sonny something?
Sonny Boreali?
That sounds right.
Okay.
Yes, I think so. I think that's the name.
And when you were there, you told the legislature you couldn't determine for sure if any votes in that election that you were reviewing were illegally counted. Fair?
I don't recall saying that, but I would say that if I were asked the question now. I don't have independent recollection to that statement, but it's a fair statement.
And based on what you've reviewed in connection with the opinion you've given today with the 2022 general election, that would also be your answer, correct? You can't say with any certainty that an improper vote was illegally counted or rejected.
I can't say one way or the other. I'm not drawing opinion that it was or was not.
Okay. Are you aware that after that hearing you testified at, the representative was eventually expelled from the House of Representatives for that hearing?
I heard something in my travels this week that someone came in and was, I don't know what the word is. Maybe you have a better word than me. Ultra excited. And I don't know. I wasn't there and I haven't seen it. I'm not trying to be funny. I just don't want to use an inflammatory word.
Sure.
But something like that. And then the person who invited him got in big trouble. I didn't know the extent of the trouble, or I didn't maybe remember it, but I heard something about it.
Now, forensic, okay, that word, that means the application of scientific principles to legal cases, right?
That's what it means to me in forensic science, yes.
Okay. Now, ultimately, the opinions you gave today through your testimony, they are based on a set of assumptions. Fair?
Objection, Your Honor. Would ask that the witness lay or counsel lay a foundation for what assumptions he's referring to.
Well, he can answer if he understands. If he doesn't understand, we can have it rephrased.
I understand the question. I'm just taking time to think what the assumptions could be because I don't
Yeah,
have.
take your time.
Give me just a second.
Sure, take your time.
Your Honor, may I also ask that counsel stop interrupting witness and let him finish his answer?
If I'm doing that, Your Honor, I apologize. I'll be better.
For the sake of my court reporter too, please.
And be slower.
Both question and answer need to slow down, please.
Of course.
I think I'm equally at fault for the pace, so we can share.
We all have better places to be, Mr. Speaking.
I agree with you. I'm at a loss as to what an assumption would be. I'm not saying there aren't any,
Okay.
but I can't think of one, and I'm not sure if I'm missing an obvious one, but perhaps you can
Sure.
give me an example and I can run from there.
Well, your opinion assumes the information you were given is adequate. It's correct.
Oh, in other words, what was asked for is what was given by the county. That's an assumption. Yes, that's true.
And it assumes the people you spoke with told you the truth, for example.
I would say assume, yeah, I see where you're going. It would assume that the totality, not only of the people that I spoke to, but the other witnesses, the videos and all that would corroborate one another, which I believe it does, but could there be one aspect that doesn't? I can't say.
In general, the assumption then is that the information that you've relied on, that you testified to today, that you relied on in forming your opinion here, the assumption is that all of that's accurate, it's reliable. Is that a fair statement?
Objection, Your Honor. I just don't know what opinion he's referring to. I would just ask that he would clarify and be specific.
Okay, if there's a specific opinion, you can rephrase it if you mean all the opinions.
I mean every one of them, Judge.
And re-ask the question so
Sure.
that he understands that.
Thank you, Your Honor. With respect to every opinion you've given here today, whatever it may be, you would agree with me that an underlying assumption, as I've been using the term, that a foundation, if you will, to the accuracy of your opinion is that the information you relied on to form that opinion was accurate and reliable. Is that a fair statement?
That the foundation for that specific opinion
Correct.
would be. Not everything that you gave me that I said I evaluated is the foundation for every
We're
opinion.
on the same page. It was a general question. I think we're on the same page. So it must follow then that if with respect to any specific information you relied on in connection with any specific opinion you gave today, if that information is unreliable, then your opinion is unreliable to that extent as well, correct?
To whatever limited extent or large extent, depending on the nature of the unreliability or questioned, it could have a small to negligible impact to a large impact. That is correct. It would be variable as to the exact situation.
And you'll agree with me, and I think you said this a moment ago, and I appreciate the candor. At this point, with respect to this case and your opinion on the 2022 general election, you really can't say one way or the other based on what you've reviewed, whether a single vote was improperly counted, one way or the other. Fair?
I'm not here to draw that opinion, and I'm not saying that.
You're not here to, so you're not giving an opinion on that.
I have not, and I intend not to, if at all possible. That is correct.
Okay, thank you. You agree with me that one relevant factor in your analysis here today with respect to your opinion as it relates to Exhibit 48,
The table?
the table, is that Exhibit 48? 47, thank you. Exhibit 47, okay? You'll agree with me that with respect to your opinion as it relates to Exhibit 47, one factor relevant to that is the number of employees, either full-time or part-time, that Maricopa County had engaged or hired to do the ballot signature comparison. Fair?
Not sure about one factor. I mean, the more they employed, the more pieces of paper it took up, if you mean that. If they had less, it'd be a smaller table. If they had more, it'd be a bigger table.
Okay, fair enough. Do you know how many employees Maricopa County hired to engage in ballot signature comparisons in the 2022 election?
For ballot signature comparisons,
Yes.
based on the data and the testimony, was 155.
Okay.
I just specifically mean the testimony of Mr. Valenzuela, or Ray, as he has to be referred to, 155, and there's jive.
Okay.
Or a line, I should say.
Now, I don't know that I heard this on direct. Who retained you to give testimony in this action?
My retainer agreement's with Mr. Olson.
With Kurt Olson?
Yes.
Okay, counsel.
Yes, the person who's asking me the question.
Yeah, and you're being paid for your testimony?
I'm being paid for my time away from my family and my time involved in the case.
As you should be. How much are you being paid?
The hourly rate my firm bills is $600 an hour for my time.
Okay.
For every minute spent, whether it's in travel or here, I'm not charging for the time that I'm sleeping and things like that.
And you'll agree with me that your job, essentially your gig, is you're a professional expert witness, fair?
I wouldn't pigeonhole myself that narrow that that's what my whole life is about, but that is the source of where I go to work every day, and that is what I do for the hours in the day when I'm not being a husband, father, and that sort of thing, yes.
Right. And you testified you're a forensic document analyst. Am I saying that right?
Yes, I said forensic document analyst and chemist.
Okay. And chemist, that your undergraduate degree, now remind me, that's a Bachelor of Arts,
Yes, from the College of Natural Science with a major in chemistry.
not a Bachelor of Science.
It is not a Bachelor of Science.
And now, forensic document analyst, that a title you just gave yourself?
No, it's a common title that's used by people in my profession with a similar background and training that I have.
And no regulatory organization gave you that title, correct?
That's right.
And there's no specific licensing requirement to call oneself a forensic document analyst, correct?
I agree, yes.
And you weren't conferred a forensic document analyst by any organization or school, correct?
I would say no, I was not. Would be fair, yes. I mean, I've been called that by organizations, but not conferred that. So the answer to the question is I have not. That's right.
But you'll agree with me that essentially in your line of work, you can call yourself whatever you want, right?
Could I call myself whatever I want? Sure.
Right.
I mean, in court, the object is you have to be proven to back that up, which I have hundreds of times. But yes, I could call myself what I want, I think. I mean, I wouldn't call myself a doctor or a lawyer, but I mean, related, yes.
You're related to a doctor or a lawyer? I'm sorry.
No, related to what I do.
My condolences if you are.
I don't think I am. That's not what I meant. I'm sorry.
You don't have a formal degree in any sort of forensic document analysis, fair?
Fair. True and true.
And true. And you're not certified as a document examiner or a signature comparison person, fair?
Fair and true. Yes,
And you aren't, sir, have you heard of the American Board of Forensic Document Examiners?
I have.
And do they give a certification of any kind for forensic document analysts?
I think they call it forensic document examiners based on the name. I don't have that, but I believe that's what they call it.
And you don't have that as well, correct?
Correct? I do not.
Okay. Now, at one point, were you a member of the American Academy of Forensic Scientists?
I was.
And as a member, you had an ethics complaint lodged against you. Does that sound right?
I did.
And shortly after that, you no longer continued to be a part of that group. You didn't renew your membership, correct?
That's exactly correct.
Okay. How many, you testified earlier that you'd taken some training courses, continuing education, is that what they are?
Sorry, when you turn around, I have a hard time hearing.
Fair enough. No, that's fair. That's fair. My apologies. I'm sorry.
That's all right.
You testified earlier, I think, that you've taken some training courses. Did I hear that correctly?
Yes, continuing education was the other
Okay.
thing. Yeah, I agree with that.
And none of those continuing education courses were in connection with determining how long someone who is working for an election department, state or county, can or should take to review signatures in compliance with the law. Is that a fair statement?
That's fair
Okay.
and true.
How many of your training courses were specifically on the speed it takes to verify signatures?
There were none of the training courses that I had or have taken that exact topic was covered.
Okay. Can I have a moment, Your Honor, to confer with counsel? I may be finished.
Okay.
Thank you, Your Honor. So I want to talk for a moment again about the assumptions we were talking about earlier. Do you remember that conversation?
Do.
Now, you'll agree with me that a pretty critical assumption, if you will, in connection with your testimony related to the table exhibit. You know what I'm talking about? The table of the, you call it the click-through table?
I didn't call it that. I know what table you mean because there's only been one.
Right, right.
But when you said the critical assumption, I'm not.
I haven't gotten to it yet. I'm
Oh.
I'm asking the question. I just want to make sure we're on the same page, Mr. Speaker. Were we on the same page so far?
Same page meaning I know the table that you're talking
Yes.
about, whatever title you give it.
Correct.
Exhibit, whatever.
Exhibit, sorry, Your Honor, Exhibit
47?
47, yes.
Thank you.
You'll agree with me that an important assumption there in the conclusions that you reach based on that exhibit is that in fact, the act of a signature verification one way or the other occurred. I should say signature comparison occurred.
Well, first, there's one problem with the question, and I'll just try to shortcut it if you'll let me.
Of course.
And that is, you said my opinion was based on the table, and that's not exactly true. As we know, it's a demonstrative, so I had the opinion the table is demonstrating it.
Sure.
I'm not trying to be nitpicky, I'm just saying.
That's fair.
The second part is you said that it's, I don't totally understand it, that it's based
Try again.
on.
Yeah, if you don't mind, because
Yes, please.
it's my fault.
Oh, that's fine. That's fine.
You'll agree with me that in order to reach any conclusion about the speed, one way or the other, with respect to what's being shown in Exhibit 47, that assumes that in fact the act of a signature comparison, whether you agree with whether it was adequate or not, the act of the signature comparison occurred.
I understand what you're saying. So yes, it does assume that the keystroke that's being logged from the computer and time-stamped is the action of some sort, whether it be a pass, a fail, a spousal exception, a no signature, a curing, whatever. There's a lot of different codes.
Sure.
But it's entering a code that relates to the signature verification process. And that was told in the response, and that's what was asked for, but I'm assuming that's what it is. You're right.
Perfect. Thank you. Your Honor, for the Secretary of State, there are no further questions. I do believe Maricopa County might have a couple.
All right. So, Mr. LaRue, you have cross-examination as well?
I do, just very brief, Your Honor.
Mhm.
Good afternoon, Mr. Specking. How are you?
I'm good.
Good. I have just a few questions for you, and I just want to be sure that the record is clear, is why I'm asking them. You alluded to some of this earlier, but I'm asking the direct questions because, as I said, I want to be sure that it's in the record clearly. You've never, well, strike that. Earlier, you were, in your testimony, you were talking about comparing signatures. Do you remember using that terminology?
Yes, I remember the word compare many, many times.
Okay. You've never compared signatures for elections under ARS 16550, have you?
Correct, I have not.
Okay. In fact, in general, when you're called to give an expert opinion about signature comparison, it generally has to do with fraud or areas such as that, not elections. Is that correct?
I've had plenty of election cases, but it is not a large percent of my overall body of cases based on handwriting. That's a true statement.
Would you say that the majority of your cases relate to fraud?
I'm not a fan of the term because it has a predisposed connotation. Perhaps determining if there was fraud, dishonesty, whatever. It's an inflammatory term, and I try not to use that in my life, let alone when I'm testifying. I get what you're saying, and I would answer generally yes. I just don't like the term fraud, but I know what you mean.
Okay, fair enough. How would you describe it?
It's trying to determine if forensic science can assist the trier of the fact with a specific question, whether somebody did or did not do something, or whether somebody did or did not write something, as we're talking in this case. In other cases, it could be when it was written, altered, changed, added to, all those things that I talked about, but I don't think you want to rehash them. But specific to handwriting, did they or did they not? I don't use the word fraud in my opinion, like, since my opinion is this, it's a fraud. Like, I would never do that.
Okay, I understand. I'm going to use the word fraud because I think you just testified, you understand what I'm meaning when I say that, even if it's not your preferred term for getting at this. Is that correct?
I'm fine answering your questions as long as you understand that's not a term that I would use, but I know what you mean.
Okay.
I'll do my best to answer it in that context.
Fair enough. Thank you. Is there a set number of signature exemplars that you are supposed to use when you do fraud examinations?
Back to what we said about, there was an argument earlier about best practices or wish lists or wanna-haves. There's an idea that I would like to get, but not a standard of must-have. I mean, you must have one, unless you're comparing multiple signatures at issue to one another, like I talked about on a ballot or a petition, which is a different scenario. but you can do it with one.
Is
Have a wish list, personally, yes.
do you know if there's an industry best practices standard?
Yes, there is.
And what is that?
An amount sufficient to make a determination.
Okay.
So it's not a numerical amount, just for the reason that I said.
Okay. Would you agree with me that, strike that, when you are doing a signature comparison for purposes of a fraud determination, say for a bank or, on a check or whatever the case may be, would you agree that the more exemplars you have, the better?
Oh, absolutely. I mean, with obvious certain limitations and ridiculous exceptions, but as a general term, 10 is better than 5, 6 is better than 3. I agree.
Okay. When you do that type of signature comparison that you and I are talking about right now for a fraud examination, say for a bank with a check that may have been fraudulently written, if you have 10 signature exemplars, is best practices to look at all 10?
If you are satisfied that those 10 are known signatures, absolutely.
Would you agree with me that if you're doing a signature comparison and you look at 10 signatures, that will take longer than if you look at 2 signatures?
It absolutely should.
And you would agree it would take longer than if you look at 1?
It absolutely should, yes.
You may not know the answer to this, and it is perfectly fine to say, I do not know. I'm not trying to lead you to say something that you don't know, okay? But are you aware of whether under Arizona law, those who do signature comparison for early ballots are required to look at a set number of exemplars?
Well, the only standards that I'm familiar with would be the EPM and the 16550A, I believe. You're nodding your head, so I think I got that right. And in those two, I'm not aware of a numerical requirement, just like in the standards in my field, that's set forth. You could surprise me and tell me there is one that I didn't see, but I'm not aware of one. I don't know if there's other laws in Arizona that pertain, so I have no way to answer that question other than those two.
Okay, fair enough. Very good. I want to go back to the table for just a moment. And it's the only table we've been discussing, so you're aware of what table I'm speaking of, correct?
I got you, yeah.
Okay. As you sit here right now, can you say with 100% certainty that any of the workers that were identified in column 1 failed to conduct signature verification?
Objection, Your Honor. The table has a number of references. Are you referring to the whole table or with respect to certain rates?
I'm referring to the table as a whole. Sorry, I turned around and I realized my voice may trail off. I'm referring to the table as a whole. The left column has workers, and there were a number of workers listed, and then there were lines going across saying, less than so many signatures, less than so many seconds, less than so many seconds, less than so many seconds. My question is, the table as a whole, the workers on that table, can you say, as you said here, with 100% certainty, that any of those workers did not conduct signature verification? Any of them?
I don't believe any of my opinions today are expressed to 100% certainty, nor can I think of any in the last 30 years that I've expressed to a 100% certainty. I generally like inflammatory terms. I try to stay away from 100% as well.
Okay. And I realize based on the answer you just gave, and I know what your next answer will be, but so that the record is clear, and then I'm done, Your Honor. As you sit here today, can you say with 100% certainty that no signature verification occurred in Maricopa County for the 2022 general election?
I would say the same answer for the same reasons, meaning no, I would not say that.
Thank you, Your Honor.
Is there any other cross-examination by any other defendant? Very well. Okay. Redirect, Mr. Olson.
Thank you. Mr. Spakeen, you were asked a number of questions where your answer was cut off regarding some cases in which you had been criticized. Was there anything that you wanted to say that you were not able to say?
Well, yes, like for instance, the letter from the judge that he read from the 13th Circuit, he skipped over the paragraph that says you clearly have some specialized knowledge and training with regard to ink identification and document examination. Your experience in grease analysis, which is what I was appointed as an expert in that case, is woefully lacking. I never disputed it in that trial. I don't dispute it today. I'm not an expert in grease. In that case, I testified to FTIR results. As a chemist, that's what I look at. I was trained in that as part of my education. I do that. It was a very simple analysis. The judge didn't like the bill and wrote me this letter. I wrote a letter back. That was the end of the issue. I've testified in this jurisdiction, but again, I mean, the judge even says here, I have specialized knowledge, skipping ahead to document examination. It was unfair the way it was read, and I understand it's cross-examination, but that's how it goes.
Any of the other cases that were presented in front of you that you'd like to comment on? One of the opinions was quite lengthy.
Well, the Hong Kong opinion, I got thrown a Court of Appeals opinion. It's this thick, double-sided, and asked if I could point to a paragraph that said something to the opposite. Obviously, I can't, as I sit here right now. I read one because I knew where it was.
And what, could you read that again? And
I'm not sure I can. Oh, this is the wrong one. Let me correct my answer and say this is the one that was handed to me from the Court of Final Appeal, not the one.
which exhibit number is that, sir?
This is 48. And there are, I'm not an expert in legal opinions, especially from Hong Kong, nor am I from the United States, but definitely not Hong Kong. I can tell you that it appears that different judges wrote different things like our Supreme Court does in some occasions. I don't know that for certain. That's just the way I take it. But the paragraph that I read just says an extraordinarily large portion consisted of pages copied verbatim from the submissions. Like in one of the paragraphs that he read from the opinion, it had the number 2, which he didn't read because it's not an audible sound. Because it was actually copied a typo from the previous ones. It talked about a testimony of 100,000 examinations. That isn't at all what I said. It was quoting a testimony from a case in Tulsa, Oklahoma called Utica Square versus Renbergs that I had testified on in 1998 about a case that I had looked at for General Motors, and there were 100,000 documents involved in the case. Then they twist the words without including the transcript and put it in their submission to the judge, and the judge photocopied it. It's completely unfair. It's from over 20 years ago. I mean, I don't know what else to say. demeaning and upsetting, and that's not at all a reflection of what happened, but that's just my opinion.
Any other opinions that were put in front of you that you'd like to comment on?
The last one was the EEOC opinion, and if you read the last part of the opinion, it wasn't that I'm not an expert at all. It says, I'll just read it exactly so I don't paraphrase it incorrectly. Spakeen's deposition testimony suggests there may be other methods to determine age that would be admissible in this case, but and go on to say, I'll just paraphrase and say, but I didn't have them in that case. There's only one method. And the judge said that method was not allowable. Keeping in mind, that's what everybody uses today, by the way.
You've qualified as an expert, I believe, and I don't want to go through everything, but you've qualified as an expert in hundreds of cases, correct?
Multiple hundreds of cases in court, yes.
And that's with respect to forensic document examination and handwriting analysis?
Yes, and ink dating, yes.
And you've also been retained by various government agencies to
Yes,
give opinions about forensic document analysis and handwriting analysis?
yes, and continue to be.
Counsel asked you some questions about the touches with respect to the data that Maricopa provided. You recall what? So that's what I want to refer to. And I believe you've probably seen in some of the testimony yesterday, there is the notion that the signature verifier will go back and check the batch of signatures that they have already compared as part of the cross-check. Do you recall that?
I remember that testimony, yes. That was from Mr. Valenzuela.
Yeah. And when the reviewer, the verifier is going back, does that result in a change that's reflected in the data?
Objection, Your Honor. I think this is beyond the scope of my cross-examination.
I don't believe it is.
Fair enough.
Thank you.
No, the request was for keystrokes of determinative outcomes, good signature, bad signature in simple terms, and there's others, and a date and timestamp associated with those. It's not date timestamping, left and right arrows, scrolling, things like that. But you do see when people are going very fast, times where there's 200 seconds with nothing that could very well be that time when someone might be scrolling back in 150 seconds, 200 seconds, whatever the case may be. And it's not logging a keystroke for that. It's just a long period of time where it doesn't log any keystrokes because there were no determinative outcomes.
So if a signature verifier is going back to review their work and not making any changes, but just going back quickly without making changes, that activity is not reflected in the data that Maricopa County provided.
Other than the increase in time for those two sequential keystroke entries, the last one before they scrolled back, and the first one, perhaps when they start a new batch, or change one very far into the batch. I mean, I don't know what they did, but it's only by a lag of seconds. It's not date time stamping those right, left scrolling clicks, whatever you want to call them.
So does the act of going back without making a change affect the rate of comparison as reflected in your analysis and in what was reflected in Exhibit 47?
No, 47 is not affected at all by whether someone did or did not scroll back, how fast they scrolled back, nothing like that.
I'd like to pull Exhibit 21. And Your Honor, if I may, can I get that exhibit and give a hard copy to the witness? It may be just easier. This is the it's a set of emails.
I don't think that's exhibit.
If you want to use Exhibit 21 to show him?
Yes, Your Honor. I want to make sure it's the right number. Mr. Spagin, you've just been handed Exhibit 21, which the first two pages are the original public rights request sent to Maricopa County on February 3rd, 2023, which underpins the data that was ultimately received in PR 1482, which underpins the data that you have drawn for your opinion, correct?
Yes,
Have you seen this document before?
I have.
Is there anything in this document that assures you that the data that Maricopa sent was complete for purposes of your analysis and opinion?
Yes, there are multiple responses to the request saying this fulfills your request. This is what it is, to that effect, that it fulfills the request of what you're requesting. And nothing to the contrary.
And what was the data that was being requested as it relates to the opinions you have offered here today and the data that is reflected in Exhibit 47?
The data that's reflected in 47 is the unique identifier. So that would be the worker, the anonymized user number for the worker, and the calculation from the date timestamp as to how much time elapsed between successive entries of date and timestamp, and then what the disposition is. That's where the percentage comes from. What percentage?
You okay?
I have a new hip and it just popped out. So I think it just popped back in. So we're okay. It just didn't feel good for a second. Sorry.
Okay, if it's your hip,
Yeah, no, I'm fine now.
you want to stand up and stretch?
I think that's the last thing I want to do, Your Honor, but thank you.
Okay, well, hold on a second. Take a break.
No, thank you. It just got me for a second there. It was like a
Got me.
stabbing pain. Sorry. I wasn't trying to give anyone else a panic there.
Well, I'm just trying to make sure, number one, you're okay.
I'm okay, Your Honor.
Not
Thank you.
Any kind of distress, and you don't need a break, because I'll give you one if you want.
No, I'm good. I'm good now. Thank you.
But just continue.
I would.
Okay.
I'm sorry. What,
You don't
before
need
that,
to-
what was the question? I don't remember.
You don't need to apologize. He's going to ask another question.
The data that Maricopa produced in connection with PRR 1482, you were referring to certain data. If you turn to the page identified at the bottom right-hand corner, Lake 21, 896, and then 897, we'll move to that as well. And this is a document that's in reverse chron order, correct? The email string?
Right. It's an email string with the newest at the top or the front.
And do you see at where it says Lake 21, 896 at the bottom right-hand corner?
Yes, I'm there.
Okay, and if you move to the top of the page, you see it's cutting off. And so it's, as you go in reverse chron order and you flip forward to 895, where it has at the bottom of 895 a date on 5/4/2023, PRR MCRO Road. Good afternoon, we the people.
Yes, I see that.
So flip back over. Do you see that on 896? That's part of the Maricopa's response to We the People.
Right. The May 4th, 3:47 p.m. response continues on to the top of 896. I follow.
And do you see the 5 items of data?
Yes.
Is this the data, or at least some of it, the data that underpins your opinions and the data reflected in Exhibit 47?
Yes. Specifically points 2, 3, and 4.
Do you have any reason to believe that the data in points 2, 3, and 4 that Maricopa provided was not complete and accurate?
No.
Turning to the Exhibit 47, Mr. LaRue asked you some questions about the overall chart that was displayed here and your opinions thereon, and said, can you say with 100% certainty that every vote, I've got his exact words, but that not every vote was properly counted or some such. Or do you recall that?
I remember the two questions about 100%, yes?
Are you offering an opinion as to whether or not a signature can be compared in 6 seconds or less?
I didn't express such an opinion. I have one, but I didn't express that, no.
But you didn't offer and express an opinion on that.
Correct?
Are you offering an opinion as to whether or not a signature can be compared in 4 seconds or less?
No, I didn't offer an opinion on that.
The opinion that you offered was with respect to comparing a signature, I think as we used before in simple terms, less than 3 seconds, correct?
That was the opinion that I expressed, and further with less than 2 seconds, you asked me as well.
And your opinion was that it was not possible to compare signatures in less than 3 seconds in the context of why we're here today, correct?
On the mass scale context, I said it cannot be done. Could you pick one time out of 10,000 where someone could do that? Maybe you could, but not on a mass scale, like in the thousands and thousands. No, it's my opinion, you cannot do that. You cannot do a comparison in that time.
Mr. LaRue asked you some questions about the having more than one reference signature. Do you recall that?
I do.
Is your opinion predicated on the existence of more than one reference signature, or that it is one signature from a ballot envelope compared to one reference signature?
Well, my opinion is not predicated on either. I gave the benefit of the doubt saying the time of only comparing one. Clearly in 2 seconds, you're not scrolling and finding 3 and comparing all 3 in 2 seconds. That's even more preposterous. But that wasn't what the opinion was based on. It's that you can't even compare one in that time. Obviously, it follows you can't compare 2, 3, or 4, because as I answered his question, that obviously takes more time.
And what do you base your opinion on the inability to compare two signatures in the context of the system that Maricopa County has employed for the 2022 general election?
My education, training, and experience. I mean, that manual or the training program does a nice job of spelling out the basics of what you would look for in handwriting. It's what I would look for. I know what to look for. I do this every day. I can't believe there could be thousands of people, and I'm not trying to be offensive when I say this, in Maricopa County that don't do this every day and had a 4-hour training or a 40-hour training that can do it so much faster than I ever could. I don't believe that, no.
In terms of the training that you saw Maricopa gives signature verification workers to compare handwriting, you recall that?
I recall the training, yes.
Are you saying that the time to compare a signature for a signature verifier would have to follow, for example, all 11 steps in order to be a valid comparison?
No, I'm not assuming they would have to follow all 11 steps. I mean, it's a guideline. I have guidelines in my industry in which case, in certain instances, you might not follow all 11 or all the steps. I understand that. Specifically, if you have an exception, I'm not going to say that word. If you have a fail, if you see that two are drastically different very quickly, that could be a fail quickly. I understand that. What is in this table and what we're talking about are the times and the percentages where it's passing, where people are saying they compared and they're consistent.
When you say they, you mean they compared the two signatures and came to a determination that the two signatures were consistent.
Right, the ballot envelope, and whether it be one or more, but at least one of the historical exemplars, I think is what people call it, reference exemplars.
And when you use the term compare, are you using that in the sense of what we see, talked about the steps of signature comparison, or as the term compare is used in the normal English language under the definition, say in Webster's, of compare?
So when I say compare, I'm not saying you have to follow the 11-step procedure to make a comparison. I'm using the word compare as you use in the English language, but it's also the same that I use, and they're in the standards in my industry of compare. To look closely to determine if two things, or in this case signatures, are similar or dissimilar, or in the form of 1550, consistent or inconsistent is the way it's phrased there.
So merely because two signatures flash up on a screen, is that a comparison in your mind?
That's my point. It's not.
And why is that?
It would be like thumbing through this opinion like this and saying, I just read it. I say I read it and you say you didn't, and you're arguing. The simple fact is no one could read it that fast. No one that I've ever encountered in my life could read it that fast. So the answer is you did not read it.
I must hesitate to say this, but I'll just say thank you. We have no further questions at this time.
Okay. Can we excuse the witness?
I have nothing further for the witness, Your Honor. Thank you.
Thank you, Mr. Spakeen. Are you okay to stand up?
We're going to know in just a second.
Well, don't, wait a minute.
Yeah,
We're not doing it that way. Let's not just see and find out. Let's.
I'm okay.
I'm good.
I had a good doctor. It's fine. Thank you for the concern, but I'm surprisingly okay.
Watch your step.
Thank you.
Your Honor, would the court like me to retrieve the exhibits and put them back?
Yes, please. That'll be fine.
Afterwards?
Yes, you can do that. Do that. Do you have any other witnesses?
Do not, Your Honor.
Okay, so plaintiffs rest.
We do, Your Honor.
Well, coincidentally, this is the time we'll take the afternoon recess. Okay, for 15 minutes, and then we'll come back and I'll address defendants. Okay.
You're going to stay.